All rise. The Court of Appeals, Division 1 is now in session.
Good morning. Please be seated. You are sitting together, so it's up to you if you're in your safety bubble, whether you want to keep your mask on or take it off. We are fine with you taking it off. We're 6 feet apart, and we're 6 feet apart from each other. So I'm taking my mask off so you can hear what I have to say. It's up to you and your discretion about whether you want to keep it on or not. We're here for oral argument in cause number CV200050, Helen, and it's Denitang et al. Versus Arizona Therapy Source Sales Service Incorporated. These proceedings are being audio and video recorded as well as live streamed, so I ask you to introduce yourself as well as your client at the beginning of your argument. Each side will have 20 minutes to present their argument. Appellant's counsel is responsible for reserving any portion of that time for rebuttals if you choose. We have read the briefs. We've discussed this case in conference. We're familiar with the facts. Please keep that in mind during your presentation. At this point, counsel, and I'm going to ask you to argue, and I know it's going to feel a little strange from a seated position, and I need you to use the microphone instead of coming up to the podium, which would cross-contaminate. I'm going to just ask you to stay where you are. All right, when you're ready.
Good morning. This is Tim Stackhouse and Megan St. Thomas on behalf of plaintiff appellant Helen Denitang. I'm going to try to reserve 5 minutes of my time for rebuttal. I'd just like briefly to point out that the issue on this appeal is the improper admission of prejudicial evidence. The sufficiency of the evidence isn't an issue, so whether or not the jury could have reached the same result without the admission of this evidence is irrelevant to this appeal. It's whether or not the jury would have.
Well, it's not entirely irrelevant to the definition of prejudice, is it?
Well, it is not, but the standard is whether or not the court can say definitely whether or not the jury would have reached the same result without the evidence versus whether or not they could have. In a case like this where part of the evidence admitted that we alleged was improper is duplicative evidence, if that were the standard, then there'd be no appeal from duplicative evidence. You could have two experts give the exact same testimony, and then on appeal there'd be no remedy because you could say that if only one of those experts was allowed to testify, the same evidence would be there.
What's the genesis of the single expert rule?
Well, I couldn't tell you historically, but it goes back to fairness and trying to avoid trials becoming a battle of the experts.
Well, if we had a two-expert rule, would the system of justice collapse? Would anything be less fair?
Well, it'd be less fair to the party with fewer resources.
It would be wasteful, I agree, but it wouldn't be inherently prejudicial from the standpoint of proof. It would be a bad way to run a railroad, but my point is just there is a lot of flexibility built into this rule and a lot of judicial discretion because we don't know how witnesses are always going to testify, and if we had 2, 3, or 10 witnesses on an issue, you could imagine a system that would not be scientifically deficient, only economically inefficient.
That's correct, but whatever rule you have, it needs to be applied equally. So when one side can only put on one expert on a topic and the other side is permitted two, prejudice would arise there. But I would like to focus on the evidence of the pre- and post-incident use of the treadmill. Under Jones, you have to lay a very careful foundation to get that evidence in. You have to show that the product or the location is in the same condition as it was on the day of the accident. You have to show that there was a method for keeping track of accidents so that if something did occur or almost occurred, you would know about it. And there's simply no foundation here. Yet Dane Dortson testified that in his time from 2010 to 2017, during his shift, you had 1 to 2 people using this treadmill per week. Over that entire 7-year period, he said no issues with it, nobody tripped, nobody fell. You had Mark Highland saying he observed the experts use it and nobody tripped, nobody fell. And then you had the experts themselves saying, I used it, I didn't trip, I didn't fall. I saw, as Mr. Leggett, and then he also said, I saw Dr. Iverson use it, he didn't stumble or fall. He talked about seeing plaintiffs use it. And what that is evidence of post-incident use of the product to infer that it's safe. Because it's safe on this day at this time for this person, that means it must have been safe on the day that Samuel Betty had his accident. And the trial court's error on this issue, it sort of goes back to early on he made a ruling. He discussed Jones, but he said, I don't believe Jones applies to this case. I understand Jones talking about if you have 100,000 products out there, then you need this robust system in place to monitor and collect and make sure everything's there. But that isn't what it is. There's no reason not to apply Jones to a case like this. And in fact, what Jones did is it overruled a rule of per se inadmissibility. And the case that it overruled was a premise liability case. So it's not a matter of having hundreds of thousands of products out there. It's a matter of this one incident, this one location. And you simply cannot have that evidence come in without laying that proper foundation that Jones requires. You have to, without that foundation, there's no way to determine how many unreported accidents there were, or how many near accidents, or how many fortuitous escapes from injury may have occurred. And it leaves the opponent of the evidence no method to ascertain and identify those who may have passed by the area under what conditions and with what risk or experience.
Counsel, I must be on a different plane here because I'm having trouble understanding what the evidence of causation was in this case.
That came from plaintiff's expert. The treadmill, it's a belt on top of like a wooden deck. That deck is supposed to be smooth so the belt glides over it. This deck was worn and kind of has some grooves in it so that when Betty stepped on it, it snagged and it stuttered. And he was a rehab patient. He had a bad knee. The stutter caused him to stumble and fall over backwards.
What was the evidence that did somebody see him fall?
Nobody saw him fall. There was a Dane Dortson, the STI employee, was I think like 15, 20 feet away, and he heard it. He said he heard a beep, which may have been pressing the stop button. And sometime 5, 10 seconds later, he heard a thump, which was Sam's head hitting the floor. But the physical evidence of the treadmill was there to show that the deck was worn, and you could take a potentially snag and stutter and cause someone to fall.
Doesn't even the presence of that evidence, doesn't that ask the jury to speculate as to what happened here?
Well, I mean, that's going to be true in any case where there are no witnesses and, the plaintiff has not been able to speak after this incident. I mean, he had spoke a few words to Mr. Dortson immediately afterwards, but since then he's been in an incapacitated state. So it does ask the jury to speculate some, but you're getting into weighing the evidence there.
The jury weighed this evidence, didn't they?
They did, but they're also weighing that against the evidence of all the experts using the treadmill saying they didn't stutter or slip. Dane
That
Dortson
includes your experts.
Right, but I mean, again, the experts were using it understanding that this treadmill is potentially defective. They weren't rehab patients. They're looking for a stutter. I mean, they're prepared for it. So, and again, going back to Jones, that one of the foundation requirements is that this item was used in the same condition and same manner as the incident in question. And so we have experts inspecting a potentially defective treadmill. That is simply not the same as a rehab patient early in the morning getting warmed up, walking with a bad knee. And the jury also heard duplicative opinions from the expert as well, and not just on the people using the treadmill without incident. Both Mr. Leggett and Dr. Iverson gave nearly identical testimony about calculating the time that it took the treadmill to stop. And I mean, that may not be the most important issue, but what it does when you have two experts saying, yes, you both came up with these calculations and came up with the same result, it lends credibility to all the rest of their testimony. It confirms what they said in this issue, so the jury is more likely to conclude, okay, it's probably right on everything else they're saying as well.
could you spend some time talking to us about the nature of the duty you contend that Arizona Therapy had here?
Well, the duty is just reasonable care. They performed an inspection. There's a fact dispute whether or not this inspection.
Is the duty not shaped by the contractual agreement they had with the STI?
Well, the duty's shaped by the industry standards. Plaintiff put on a testimony from experts in the industry saying that this type of inspection he performed, you need to do more than just make sure it's not going to electrocute somebody that's on it. You're going to expect more than just the electrical and actually look at.
But it's a question of duty to whom? I mean, where do you get the proposition that there was a duty to every user of the treadmill?
It's people are coming to the foreseeable path.
You just crossed the Gibson line. We're asking about the existence of duty. The word foreseeability does not belong in your answer.
It's the treadmill is inside a physical rehabilitation place. He stuck a sticker on it saying, it passed a safety inspection. Users that come to that are going to expect it to be safe. And again, this goes back.
But that's pretty thin for a Kiraz-Gibson analysis. Can you do better than just saying there's a sticker? Because the duty has to exist as a matter of law, right? And so far, we don't have any law that gets us there. You've got an electrical inspector who does one thing to a treadmill, and you're saying that now creates a duty to the general public. Under Gibson and Kiraz, I think you have to be a little bit more express about how you get there. Under Paul's graph, you wouldn't.
Correct. Well, the question of duty was, it was raised in the court below, but again, we don't know what the jury decided on. The jury
doesn't decide whether there's a duty. I'm asking you as a matter of law, and I think Judge Winthrop is too. Where does the duty come from as a matter of law? The jury's irrelevant to that question.
Right. It's like I alluded to a similar example in the briefs. If a mechanic negligently repairs someone's brakes, and then that person goes out and drives and doesn't stop and hits someone, that's, as a matter of law, the mechanic has a duty to perform his.
The mechanic contracted with the person who owns the vehicle to do a specific function that was a safety issue in causing the accident. In this case, the therapy place hired Arizona Therapy to come in and test their electrical systems for their exercise equipment. That's much different than me going to take my car in, hiring a mechanic to fix my brakes, and they fail and I get in an accident. How do we get from the rehab place hired Arizona Therapy to test equipment for electricity and electrical functions, and you would concede that this was not an electrical accident?
That's correct, but the evidence was that the industry standard required this inspection. What you termed the inspection, the sticker you put on it, it had to be broader than just an electrical inspection.
But is that really true, counsel, when the evidence, as I understand it, is that STI had and performed the duty of inspection, a safety inspection on the equipment?
That's correct. But
can you really argue that Arizona Therapy assumed that's a duty that was already being performed by somebody else?
Well, again, let's just use the mechanic example again. The mechanic says, if somebody comes in, my brakes are bad. Mechanic takes the tires off, replaces the brakes in, but he never looks at the tires. The customer leaves, turns out the tires were threadbare on their last leg, half a mile away, the tire explodes, causes an accident. In that case, there would clearly be a duty on the mechanic arising out of the industry standards.
But you're now, in your hypothetical, you're presupposing that they undertook to repair the vehicle. So if I take my car in for an oil change and they offer whatever, 27-point safety inspection that they say, which basically means your air filter's okay, and then I get into an accident, you're going to say that the person who changed my oil is now somehow liable because they said the vehicle looks okay?
Well,
And we don't know at this point whether I just failed to stop at a red light or anything, but you're saying this oil changer has a legal duty under Gibson and Carraz to some third party. That is not something I've seen support for in any Arizona case.
Well, I mean, the legal duties performed to the industry standards. If you perform a safety inspection on a car, and if you notice the tires are bad, and don't tell the customer, or, if you say I performed a safety inspection, I performed this inspection on this car up to industry standards, but you never inspect the tires, and the tires blow out, causing an injury,
We may be getting too far out of afield with the hypotheticals. Let's bring it back down to the law. Isn't the law that when you contract to perform a service, your obligations are contractual and you don't assume tort duties to the entire world?
All right. But it's, you contract to perform to the industry standards. The testimony, the evidence before the trial court was that the industry standard, when you perform this type of inspection on a treadmill inside of a rehab center, is you have to check this deck. And, he was a professional. There's professional standards that apply to him. And, even if STI didn't specifically ask him to do that, he would be under some obligation for the industry standards to still perform it, to still inform them, to still notify them that, you have to do these inspections of the deck. And I would like to reserve the rest of my time for rebuttal.
Thank you. Counsel.
Good morning, Your Honors. My name is Christopher Robbins. I'm here on behalf of the defendant appellee, Arizona Therapy. I'm with Tim Moulton, who tried the case. Your Honors, I was going to say much of what you've already said, and so I think I may be fairly brief here. Sam Beatty was badly hurt when he fell at an STI facility on July 18, 2013. He settled with STI, and then his lawyers do what good lawyers do. They looked around to see if they could find anybody else who might possibly be liable here. And they settled on Arizona Therapy because the company's sticker was on the treadmill.
Well, Mr. Robbins, could you comment on Mr. Stackhouse's argument or reliance on the fact that industry standards applicable to Arizona Therapy expanded what may be a limited duty of inspection?
There's no case law to support that. I've never heard that before. What Arizona Therapy contracted to do was to do electrical safety inspections to prevent electrical shocks and fire hazards, period.
And what does that consist of?
Ellen Stotts, the owner, talked about it at length.
I know, and I have a purpose here, believe me. I'm just trying to
Okay.
boil it down to a very small distillation of number of steps to help our discussion.
As I recall, you check the cord, obviously the power cord, check that it goes up and down, check the speed of the belt.
They don't disassemble the control unit and
No.
check for leaky
No.
capacitors?
They have, and I apologize, I forget the tool that he uses. Their expert, doctor, I believe I can't remember now whether it was Dr. Paulus or Dr. Knapp also talked about it. But basically, you're looking at the electricity and making the electrical functions of it and making sure it works. Their expert, Dr. David Paulus, did say that this had nothing to do with electrical. What they're claiming is that that the belt was worn and that it might have been shaking or something like that. In other words, a mechanical problem with the treadmill. That's what their experts said.
Was there any testimony that in making that sort of limited evaluation of the electrical system would have required the Arizona Therapy technician to lift up the belt and then would have observed something looking like a mechanical problem. or a
No,
safety issue.
Arizona Therapy basically is Alan Stotts. It was Alan Stotts who would come in once a year, check the electrical systems on these as he was contracted to do. If I could read from, Mr. Gill is not here today, but this is what he said in closing argument, and I'm reading at page 37 of day 8. He said, "This case isn't complex. It's a very factual and simplistic case. What I think it boils down to is what was Alan Stotts' role? What was Arizona Therapy hired to come and do specifically with this treadmill? The only testimony was from Alan Stotts, STI employee Dane Dorston, and sort of tangentially Mark Hyland, the manager over STI facilities. They said his sole role was to come in and check the electrical on this treadmill. That was it. They have no evidence that the electrical inspection was in any way negligent. They don't even allege that it was the electrical components of the treadmill that allegedly caused any
Were there ever
problem.
allegations that there was an electrical component that was designed to detect and mitigate mechanical problems?
No,
So there's no control unit with a sensor that detects vibrations or friction and shuts it down, nothing like that?
not in the 9 days or 8 days of testimony, Your Honor. Your Honor, Judge Winthrop, I believe you asked about evidence of cause. Their expert, Dr. Carrie Knapp, said cause was all speculative. And for that, I'm looking at day 4. He was on cross-examination. Tim was saying, let's go back and look at the deposition that you gave in this case. And Mr. Knapp testified under oath in deposition, the cause of Mr. Beatty's fall is open to speculation. He said yes. He says, we don't know the cause. So Tim said, what you're saying is it's speculation to know the cause of the fall. The answer is yes. Did I read that correctly from your deposition? And Dr. Knapp says, that was my testimony under oath. So yes, there's zero evidence that this treadmill caused anything. In fact, I made a list of 9 reasons supporting the jury's general defense verdict and showing that there's no prejudice. We've already talked about some of them. I believe it was Judge Swan who talked about STI. STI had the duty to inspect this treadmill daily, weekly, monthly. STI did everything. And that's why they sued STI and said, STI, you're 100% liable in this case. They claim that in the lawsuit. Mark Hyland, the STI employee, said, yeah, that's what they alleged against us. Their experts all testified that it was STI who had allowed this defective and unreasonably dangerous treadmill to remain on the facility. It was STI who owned the treadmill. It was STI that owned the facility. Sam was there as a patient of STI. Mr. Stackhouse agreed that nobody witnessed this. We don't know what happened. And every bit of circumstantial evidence suggests that the treadmill was stopped. Sam had stepped off the treadmill and fell. Our expert, Dr. Barry Hendon, said it might have been a tonic seizure without any regard whatsoever to the treadmill. That might have been the cause of his fall. Dr. Johan Iverson said whether or not he fell from the treadmill or just fell from the floor, the same forces would have been applied to the back of his head, resulting in this horrendous injury. There is just reason after reason why the jury could have entered its general defense verdict, and they address one. That's not the way the law works. They can't go and pick out some error when there's 8 other reasons to support the jury's verdict. If I can read from a very, very wise man writing, having faith in the jury system, we believe jurors can handle the problem. Whether or not the jury finds plaintiff's claims well-founded, we are willing to indulge the presumption that the jurors will probably be right, or at least as right as the trial judge and we might be on this and the many other difficult issues of fact that come before our courts. That was Justice Feldman in the Lagerquist case. We believe in juries.
Not exactly. That's a surprising citation. Not exactly the high watermark of Arizona jurisprudence.
No, not exactly. Your
Completely discredited and rejected case at this point.
But what it shows is that he believed in jurors. He believed in the power of the jury, which we all do. That's why the standard of review.
Justice Bales seemed a little less inclined to make that leap before at least performing an illegal analysis about duty.
Yes.
And I would
cases,
argue
Your Honor.
that Justice Feldman also embraced that view in Markowitz, but our current status is not just throw it to the jury. We do an analysis of legal duty first.
Right. And exactly. So there was no legal duty here.
I'm not surprised to hear you contend that.
Alan Stotts he had no common law duty to come into somebody else's facility and to do something to their treadmills to protect some unknown person who might come in 2 months later. He didn't have a common law duty. He had a contractual duty to do an electrical safety inspection. He did. He did the same thing I've always done, that I'd been doing for years before, that I've done for years after. Dane Dorston, the STI employee, said he always comes in, he does a professional job, he does exactly what we asked him to do. There was no duty here. There was no breach of the standard of care, and there was no evidence of proximate causation. I'm going to stop unless Your Honors have further questions. Thank you, Your Honors.
Thank you. Counsel, when you're ready.
Yes, I'd just like briefly to go back to this question of duty. It was STI as a rehab center, they had a statutory duty under the administrative code to inspect this treadmill. There's testimony from Mark Hyland, the owner of STI, that he delegated this task, this duty, to AZ Therapy.
Which duty?
The duty under the administrative code to inspect the treadmill and just sort of to generally ensure safety. But
Does the administrative code require a single person to be responsible for the inspection, or can different people undertake different parts of the inspection function for STI?
It's not really a question of whether or not the duty can be delegated or broken up, but the duty exists, and the testimony was that Mark Hyland delegated to it. But I would also like to point out that nowhere the appellee doesn't raise the denial of a motion summary judgment or the denial of a motion for judgment as a matter of law.
Denial of a motion for summary judgment is not appealable.
Or a denial of a motion for a judgment as a matter of law. And so this whole question of duty that we're arguing now is a legal question that was not properly raised in the answering brief. They argue the sufficiency of the evidence. They don't argue there is legal error in even submitting it to the jury.
Well, you're arguing prejudice, and prejudice only exists if the result would have changed but for the error. And I'm still struggling to see how this defendant, I mean, I'm not denying the seriousness of the injuries, but we have to be even more careful when we're talking about potentially large verdicts about inflicting them upon the wrong people. And I'm struggling to see why this defendant is on the hook for an injury that obviously had enough seriousness that you're able to settle with the primary defendant. Am I really to tell the public that if we had streamlined the expert testimony here, that all the other issues of duty, causation, and everything else would and your own expert's testimony about causation would have somehow vanished and the verdict would have been different?
Well, it could have been the same, but we can't say for certain that it would have been the same. And the primary, the thrust of our appeal is not necessarily the expert opinions, but the safety history. Lots of people used it beforehand, lots of people used it afterwards. And, as Joan says that, one of the reasons why this evidence used to always be precluded was that jurors would be misled or prejudiced by such evidence. Lest jurors impressed by the defendant's good record might be swayed in his favor and fail to see that he had lowered his standards. And that's the primary issue here that in our appeal that we're complaining about, that this evidence of years before, this treadmill has been around since 1994. So that's almost 20 years of history that we'd have to go back through and examine and, dig up past employees of STI and employees of STI afterward. And it's just not tenable to, expect a plaintiff to rebut this evidence when the defendant is able to put on specific incidences of people using it.
But it's tenable to ask counsel for a citation to authority to establish a legal duty.
Well,
I guess that question's still hanging out there.
And do you have any code site? It's the STI delegated the duty that they have to inspect the treadmills, to inspect the equipment. The regulation is R9-10-130. 1030. It says that administrators ensure that an outpatient rehab facility, the equipment is maintained and safely inspected. And Mark Hyland, there's conflicting testimony on this, but Mark Hyland testified that he delegated this task, his duty under the regulations, to Arizona Therapy. There's testimony that somebody in Arizona Therapy's industry in that field, when that task is delegated to them, they have to do more than simply check the electrical. They have to do the mechanical. And when they certify by putting that sticker on it, that's what they're telling the world, is that I did more than the electrical. That was the testimony before the trial court. And I believe I'm out of time.
You are. At this point, we will take your arguments under advisement, issue a written ruling in due course. I thank you all for your arguments here today. Please be safe out there, and we are adjourned.
Thank you.